put everything on there that I need to. I think it all takes is my signature, isn't it?
I don't know if Cody is or Dennis is.
Okay, we're ready?
Hold on a second.
Nope.
I need to sign that?
Put your X.
What?
X.
Oh, I heard something different.
Good morning. We are on the record. Today is Monday, November the 14th, at the Real Estate Appraisers Commission meeting. I will turn it over to the chair for today, Mr. Randall Thomas. It's all yours.
All right, we want to call the meeting to order. Roxanne, will you read the notice?
Yes, the updated agenda was posted on the website for the Appraisers Commission on November the 9th, 2016. If we can motion and adopt that agenda.
We have a motion to adopt the agenda. There, a second?
Second.
Any discussion? Corrections? All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you.
I'm going to do the roll call. Mr. Rex Garrison,
Here.
Timothy Walton. Mr. Walton is not here. Mark Johnston,
Here.
Randall Thomas,
Here.
Norman Hall. Mr. Hall is not here. Eric Collinsworth.
Here.
Rosemary Johnson, not here. Dr. Warren McCara.
Here.
Michael Tankersley.
Here.
All accounted for. Thank you.
And we do have a quorum.
Yes, we do.
Okay. Roxanne, at this point, do we want to move our new business up?
If it's okay, could we go ahead and do the minutes from the last meeting? If we
Sure.
could get I need a motion to accept those.
Okay, motion to accept the minutes from the last meeting, please.
So moved.
Second.
I'll second.
All right, we have a motion and second to approve the minutes from last meeting. All those in favor say aye.
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 Any opposed? Motion carries.
Thank you. And because we have someone appearing before the commission, I thought we would skip, if it was okay with everyone. On your iPads, on page 59 is a letter for your review. We also handed out a letter in support of, and so you have before you Mr. Todd Rogers. Mr. Rogers, we will turn it over to you. If the board will have a minute to review the letter and get to the right place, if you'll give them a second. Thank you. And on the iPad, if you'll just make sure, or on your mic, that the red button is on when you're speaking.
Sure, okay.
Perfect. Thank you. Page 59 on your iPads.
Mr. Rogers, while my colleagues are reading this, I want to ask you two questions.
Yes, sir.
Number one, are you currently or at some time in the past, has someone filed a complaint against you where there was an ocean of time between the effective date of your appraisal and when they filed the complaint?
No, sir, I've
Okay.
never had a complaint filed
Okay,
against me.
great. And are you here representing a group or just by yourself?
Well, I am the Government Relations Chair of the Appraisal Institute, but
Okay.
I'm also involved with Tennessee Appraiser Coalition. And so I am advocating on behalf of appraisers generally, but not, I wouldn't say, well, I'll just say I'm involved with those groups, and this is an issue that has come up repeatedly
Sure.
from appraisers, so that's the reason why we're here.
Okay. Everybody had an opportunity to read the letter? All right, Mr. Rogers, I'll turn the floor over to you, sir.
Okay, and I'm going to keep this as brief as possible. Obviously, the letter kind of spells out that we are interested in trying to get the a limit on the filing of complaints in line with the record-keeping rule. For several reasons. First, we don't think that it would be reasonable to have a complaint filed against somebody after they have potentially destroyed their file according to the uniform standards. And we also think that, well, I'll speak on for myself, but I think if you can't be expected to keep a file for, 15, 20 years, I mean, that's not the current rule under the state code or for uniform standards. The other thing I think that I just wanted to mention is that if somebody were to file say a civil complaint and before that they decided to turn an appraiser in, and this was many years down the road from when they did the appraisal, the appraiser would be subjected to review by you all, and my understanding is this, obviously the standards that would apply would be the standards that were in effect at that time, which is somewhat of a burden on the Appraiser Commission to remember and recall and understand all of the standards that were in effect perhaps 10 to 15 years ago, when those standards are changing every 2-year cycle. So that's another issue that, you know, is to be considered. But just from the standpoint of just being reasonable, it seems that the period of time should be in line with the record-keeping rule, and other states have gone to that and have those limits on the books. North Carolina, which I had included, and I also wanted to note that Illinois has a statute on the books. I have a copy of that. I don't know if I could enter that in or pass it out or provide a copy to you guys. Okay. I have several copies if you, I don't know. No.
You have the citation for the Illinois statute?
It's 225 ILCS, and then it's 458/15-30.
Thank you.
And, yes, sir.
Is the North Carolina language the same as what you have suggested here in your document?
It is.
Okay, because I know this is a little bit different language. in the
It
Illinois.
is. This was just kind of an example of what could be done. And again, on the North Carolina statute, they have, as I mentioned, they have certain exceptions, and you should have that documentation as well when it's involved with fraud and dishonesty, and let's see here, fraud, misrepresentation, or deceit. I believe they allow complaints to be filed indefinitely under that circumstance. But under normal, if it was I guess, normal errors and omissions or just negligence, the limit would follow the record-keeping rule. That's my understanding.
Non-appraiser here. Is there no statute of limitations for filing complaints now?
We do not currently have one on the books.
Not at all. So, I mean, it could be 100 years old, literally. Okay. Thank you.
That's
I do
my
try to make
understanding.
that note if it's
Back when you were a little boy.
old.
This still wouldn't preclude a file against an E&O policy. I mean, a lender could still do that if they wanted to.
Yeah, and I don't have a study to back this up, but if, I think that if somebody's, perhaps, like I said, we're going to file a civil suit and wanted to try to, nail an appraiser 10, 13, 15 years down the road, when it may be frivolous at that point. So it just seems reasonable to have it in line, like I said, with the record-keeping rule. And I don't know how this would be administered, if this could just be a policy and not have to go through and it would have to be a statute, added to the statute. I don't know.
We could do it through rulemaking.
Yeah, it's gonna have to be rulemaking
But
or
not
a
policy.
statute, either one, yeah.
Okay, rulemaking.
Yeah, and the only reason I say that is had a chance to speak to council before, and I could see if one of the major 4 lending institutions in the country came in here and opposed us, it will have more teeth if we can do it by statute versus just one of our policies. You are aware, I suppose, that there's a company out of a West Coast state that's buying loans and going back and suing appraisers, aren't you? I mean, there is a company that's doing that, and they're buying loans that are in bankruptcy 12, 15 years ago, when an appraiser has absolutely no idea. He probably doesn't even remember he did the appraisal. And they're buying them, and they're going back and suing or trying to settle up with E&O companies. So what you're talking about is going on. I don't know if it's come to Tennessee yet, but.
Sounds like they're just chasing some money and.
Well, because
More or less.
we have insurance. So,
Right.
that's kind of an open door there.
is a pretty normal thing to have in rules. I know that the Real Estate Commission does have essentially a statute of limitations on their complaints. I don't see it as being a bad idea. I can draft up a couple rule ideas for you guys to look at. Do you have preference? Do you want to follow the rule keeping time frame, or do you want to do like a 2-year time frame, or?
I think it needs to be in concert with what USPAP has.
Okay.
We would agree with that, by the way.
Okay. Anybody have any further questions for Mr. Rogers?
I'm just surprised this hasn't come up before.
I think it,
Okay.
yeah, I was gonna say, I think it has, but,
Wasn't pursued any further.
yeah, nobody did anything about it. You have anything else to add, Mr. Rogers?
I don't know if Creighton would like to speak, or, this is Bill Medley. Y'all probably know Bill, some of you, or not, if not all of you. Do you guys have anything you'd like to say?
I am the Vice President of the Tennessee Appraiser Coalition. My name is Creighton Cross, and this is definitely something that our members have supported. This year I've received a lot of information. Obviously, you all have the letter from support. Mr. Woodford and his firm, is in favor of this as well, previous commissioner. We have a lot of material on this from other states and how this has been outlined, so we would love to work with council in however we can to make this a part of our.
Do you know if there are any other states that lack any kind of a statute of limitations on complaints?
I believe so. This is becoming a problem for appraisers in particular in other states. I know Georgia is working on one at this time. It's my understanding Kentucky is also working on one at this time.
I guess one of my questions would be, are there any benefits in not having a statute of limitations from a legal perspective?
I mean, not necessarily. If I see one that's too old, I mean, if someone's going after, an appraisal that was done in the early 2000s, I try to make a note of that in your legal report so that you all do know it. Just because, I mean, most civil cases have a statute of limitations, so you run into that issue, so.
Does anyone on the commission have any thoughts about what the advantages are of not having any kind of statute of limitations? Are there any arguments in favor of that?
I wouldn't know of any.
One thing that was brought up, Peter Christensen with LIA Administrators, which is a large E&O company for appraisers, drafted a document that showcased the statute of liability for administrative issues, concerns, complaints, civil issues with appraisers. And Tennessee does have a discovery rule, statute of limitations. I believe it's 4 years. And that was the same as North Carolina. And that's one of the things in which, without this record-keeping rule on the books, essentially a file could be brought up and, years down the road, and based on the way it's written now, we would have 4 years from that point, statute of limitations. So virtually into perpetuity. You can open the book, open the door on appraisers for their liability. So what this effectively does is this caps that at 5 years.
So that's what
Obviously,
you're recommending or proposing as a 5-year?
is the 5-year in line with USPAP's record-keeping
Yeah,
rule.
he's recommending we go along with USPAP 5 and 7, or 5 and 2.
Very fair.
There you
Yeah.
go. There's 5 years, and if it's in litigation already, 2 years after the disposition of the legal case.
Have you thought about, is there anything, knowing what our mission is there anything, if we do this, that's harmful to the public?
No.
Okay.
Ours would
that's-
essentially set out that it would be the later of 5 years from the effective date or 2 years from
Okay.
the date litigation. Do you want an exception in there for anything? Fraud?
I was going to ask you, are there causes for exceptions to this under unusual circumstances, and what would
'Cause
those
if-
unusual circumstances
Like he
be?
made note that North Carolina does have a few set aside that they,
Notes the GSE 93-1, 12B, 124. I'm assuming, is that
I think it's on the
in
following
regards?
page.
Yeah, is that in regards to fraudulent or anything to that effect?
All right, anybody else?
I was just wondering if the appraisers believe that there is any exceptions other than fraud that would warrant, if we come up with a statute, if the legal comes up with a statute of limitations, that we would want to see that waived under certain circumstances. Can you think of any, other than fraud or misinformation?
Misinformation, fraud, any kind of, I don't know if any kind of criminal activity. Yeah.
Have you had Sarah, have you had a chance to look at both North Carolina and Illinois in this?
I've not.
Okay.
I would like to take a look at them later and just see what other states. I may reach out also to, you said Kentucky's working on it? Reach out to Larry Disney and see what they're doing in Kentucky, just to.
Okay. At this point, do we need to take a vote on this?
It might not hurt to take a vote that you would like me to draft some rules for the next meeting.
I move that that be done.
I'll second that.
All right, we have a motion and a second that we move forward on Mr. Rogers' proposal, that we take to legal a time limit of statute limitations for filing a complaint. Any further discussion? All those in favor, please say aye.
Aye.
Any opposed? Motion carries. Miss Sarah, you'll take care of that? Yes, sir. Okay. Mr. Rogers, thank you very much.
Thank you.
We look
Really
forward to working,
appreciate it.
we look forward to working with all of you.
Okay, just really quick question. Do we need to come back at another meeting to follow up on what we're doing here?
So essentially what this will do, we will attempt to do this through a proposed rulemaking. So I'll bring it back to the board. They'll look at it. It'll go to the AG's office. It'll go to the Secretary of State. If we have, I think it's 10 people object to it, then it'll have to go through a formal rulemaking process. And so at that time, we would let you all know that there's a rulemaking process and you can come speak to, you know, you're advocating for it. And you can come to the rulemaking hearing. I don't see a lot of objections coming about from this, so should be smooth sailing. We can keep you updated because at one point we will have to go in front of the Joint Government Operations Committee and answer any questions. And if we get any opposition, it'll be over there and we can let you know so that you can come to that as well in favor of it.
Thank you for bringing that to our
At
attention.
this point in time, we'll just keep you informed.
Okay.
All right,
Sounds
thank you
good.
very much.
Thank you.
We appreciate that.
All right.
Yeah, feel free to reach out to me if you ever have any questions where we are in the process.
Okay.
All right,
Really appreciate it.
move on to experience interviews.
Yes, sir. Back to you.
All right, we're going to move on to experience interviews. Mr. Johnstone, you're first.
I did not have an interview,
Oh,
but I can make a recommendation if I would have had one.
thank you, sir.
Your iPads, page 29 has the 4 that were conducted today.
Okay, I'm on the wrong page. Hang on. There we go. All right, Eric, go ahead.
I conducted just a 500-hour interview with Christopher Richard Benton this morning. The interview went very well. I think to this level, he has demonstrated good knowledge of the requirements of USPAP and the valuation process. We had a good discussion, went over a few different suggestions and ideas, and I approve, or I suggest that we approve his 500-hour limitation be removed.
Okay,
There's no vote is
Doesn't-
required on this.
Doesn't require it. It doesn't require a vote.
okay, thank you. Mr. Collinsworth, I appreciate him coming in, willing to do that. Rex, Mr.
Yes.
Garrison?
I met with Brittany Claire Belton Netherland this morning, and she is looking to upgrade from a trainee to a certified residential. I reviewed 3 of her reports, and we discussed the reports, and she appears to grasp USPAP and understand. We went over a few suggestions and comments, and therefore I recommend that she be upgraded from a trainee to a certified residential. Also, I'd like to note on our form, it says that she has not passed the exam, but last week, she took the exam and passed the exam.
Very
Thank
good.
you.
Very good. All right, recommendations come from Commissioner Garrison to approve Ms. Netherland from trainee to certified residential.
Make a motion to approve Mr. Garrison's recommendation.
Second,
I second that.
we got a motion and second to approve Mr. Garrison's recommendation. Any further discussion? All those in favor say aye.
Aye.
All those opposed? Congratulations, Ms. Netherland, if you're in the room. All righty. Mr. Commissioner Tankersley.
I got the opportunity to talk with Elizabeth Jordan Peacock today, reviewed 3 of her reports. She is moving from trainee to certified general. We talked about her experience, how the process worked within her office. The reports were top-notch. I felt like I was really nitpicking for the 1 or 2 things that I did suggest that she could improve on. They were very, very minor. I would recommend that she be approved for her upgrade request.
Alrighty. Recommendation's been made by Commissioner Tankersley to approve Ms. Peacock.
So moved.
Second.
Got a motion and a second. Any further discussion? All those in favor say aye.
Aye.
Any opposed? All right, congratulations, Ms. Peacock. If you're in the room, you're moved up. The next interview I conducted with Timothy Waldrop. Tim is going from trainee to certified residential. He too has a decent grasp on what is going on and is knowledgeable. The appraisal business, has been in the real estate business for quite some time. We did go over a few suggestions that I thought would help him along the way. However, he did submit 3 reports that were 2014. So at this point, I have asked him to submit 1 2016 report to us. So what I would like the commission to vote on is, when I look at that 16, if it does what I'm hoping it'll do, we can go ahead and move him up. So Dennis told me that the report would be sent to him and he would send it to me. So that would be my recommendation. It is after I look at 1 more report, then we can move him up if it so deemed necessary.
I would move we would accept to do that. This is something that you'll do on your time, and you'll notify Dennis your results.
Yes. Do I hear a second?
A second.
All right, we got a motion and a second. All those in favor say aye.
Aye.
Opposed? All right, as soon as I get that, I'll take a look at it and we'll go from there. Thank you all. Dr. McCary, education report.
Okay, we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, a dozen courses for, all of them are continuing education. All of them except 1. The first one are traditional classroom. The first one, course number 1959, is as an online course. And then there are also 3 individual course approvals. I recommend approval for all of these courses.
All right, you've heard the education report. Do I hear a recommendation we approve it?
So moved.
Second?
Second.
We've got a motion and a second to approve the education report. Any further discussion? All those in favor say aye.
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 Any opposed? Thank you, Dr. McCary. Now, our director's report.
Thank you. We are on page 31 of your iPads. I think you've probably seen this final recap of the finances. If not, I'll give you a minute to kind of take a look at it. The closing for 2015-2016 fiscal year is on there. If you've got questions, I can always follow up with finance if we wanted to look at any of the numbers. For the fiscal year ending, we finished in $295,388 in the positive, so that's good. And then the bottom figure includes all of our reserves. And then the next page is kind of what we're going to be getting on a monthly basis. The cost backs were always a mystery till year end, if you will. So when we do the month-to-month analysis on our revenues and then the expenses, it'll include based on percentage of licensees and everything else that's gone on each month. We'll actually have some cost back. So some months, depending, and I don't think this particular commission will have an issue, but some months it could look like we didn't bring in as much as we spent, just depending on renewal cycles and that kind of thing. But for July, August, and September, those are the numbers that we've got so far, and still showing a surplus of $29,000. And so that's just for the year. But the good thing with this type of breakdown is some of the cost backs are already in there for us to have an idea of what's there.
Appraisers renew all throughout the year, right?
Correct.
Okay.
Yes. And so when we were in Washington, D.C., which, by the way, was a fantastic opportunity for me to learn an awful lot, so I really, really appreciated that. One of the things we talked about is just our licensing numbers, and I thought I'd give you all a quick recap of where we are. I knew that the board had a little under 2,400 as the commission. Just for general information. And so I ran the numbers before I left on Thursday. We have, for licensed real estate appraisers, a total of 101. Appraisal management companies, 159. Appraiser temporary permits, 141. Certified general real estate appraisers, 826. Certified real estate appraisers, the other one was general. Certified general real estate appraisers is the 826, and certified residential real estate is 933, and the registered trainees are 186. And so those are our active licensees for a total of 2,346. And those numbers can fluctuate depending on who's renewed and not renewed, but that kind of gives you an overall idea of our numbers that we discussed.
And that 2346 is including the AMCs, you said?
That is correct. So the
really-
appraisal management companies are at 159.
That just seems low, actually. It does go down quite a few.
Yeah. And I'll be happy to update those periodically, just as you want to have an idea.
And of those 2346, what's the average age? Be nice now.
Yeah, I didn't run the dates of birth, but, so that's all that I've got for you right now. We will turn it over to Sarah for your legal report, and you're starting with case 1 on page 33.
Okay, I passed out a new number 5. I had to make a revision to the one that was sent to you. I had to take something out. So if you feel the need to recuse yourself based on what was in it, if you can recall, then you need to recuse yourself. If you don't remember seeing what I took out, then we're good to go. Just to give you all a little bit of a heads up, Roxy and I have not yet mentioned that, but we do have our ASC audit in January. They will be here.
January the 11th, I believe, and I've got, before everyone leaves, I want to hand you the 2017 dates. I know we voted them in, but we want to make sure and still hand them to you. So January 11th is an odd meeting date, but it's because they want to be here present to present everything. And so we will definitely hand these out, and that's when they'll be here. We've been handing them, and thanks to Dennis keeping on top of it, giving them everything they've been asking for the audit. So it's moving right along.
They will be here that Monday, Tuesday, and then at our meeting on Wednesday morning. I will be handling that meeting, but that will be my last meeting to do the legal report for you all. Legal is going through a restructure. I will do all of your basic board business. I will still be here at every one of your meetings. I'll answer all your questions. Any general questions you all have will go to me. I'll do all your rulemaking, all your legislation, handle the day-to-day questions from Roxana and Cody's team. But the legal report will now be prepared by the disciplinary council, and our disciplinary council will be Robin Ryan, I'm sure that you've met her, and Dennis Gregory. And so they will prepare the legal report and present it to you. They're currently litigators, so we're trying this to streamline it so they handle the case from the beginning to the end. So right now, I get the cases when they come in, and then if they go to litigation, I have to pass them off, and they essentially have to relearn the case. This way, they will handle it from the beginning to the end. So. But they will not be attending the meeting in January because your date conflicts with the Real Estate Commission. So they will be attending the Real Estate Commission meeting for me, and I will be attending your meeting since the ASC will be there. So any questions you have on that, just feel free to ask. So case number 1 is 20160293 run, and this is a represent from the September meeting. And the only note I had on this is just to let you all know, in my recommendation, it said that we didn't send a notice of violations letter. Essentially, when I get the review back from the expert, I draft up all of the violations that the expert sees and take off the use PAP violations, and I send it to the appraiser, the respondent, to give them the opportunity to kind of tell me, oh no, they missed that, it was on this page, or I'm sorry, I've changed, or, I mean, a lot of them will say, oh, I've taken a course on that since then, and I feel like I understand that. So this respondent did not receive a notice of violations, which is completely on my error. But he had some responses, and I thought I would give you the opportunity to read those. And I mean, I think now at this point it should be dismissed against him after reviewing his responses.
Because I wasn't here, can I ask why it's been handed down from last month to this month?
Well, last month we did a letter of instruction, and when I sent him that letter of instruction, he called me back and said, hey, wait, I have some responses to these violations. And so I failed to send him a notice of violations letter.
Okay.
Usually I do that ahead of time, and then I can give you all the response, but he didn't have that opportunity. So below on page 2, I sent him the violations that were found, and he responded, and the the bolded italics were his responses to the 2 violations that were found.
This was something the reviewer missed also?
No, so when I presented it to you last time, I had thought that he did not respond to the notice of violations letter, when in fact we found out that he had never received one. So he saw what the reviewer noticed, and he thinks that he covered what the reviewer said that he missed, so.
I'd like to make a motion to accept legal's recommendation for a dismissal of this case.
Motion been made and second to accept legal's recommendation on case number 1. Any further discussion? Anybody have any questions? All those in favor say aye.
Aye.
Any opposed? Okay, number 1.
Number 2 is 2016043471.
What's legal's recommendation?
Recommendation on this one is to dismiss.
I move we accept legal's recommendation to have this case dismissed.
Second.
Motion's been made and second to dismiss this case. Any further discussion? All those in favor, please say aye.
Aye.
Any opposed? Number 2's recommendation carries.
Number 3 is 2016048091.
Y'all need more time? What's legal's recommendation on 3?
Council recommends authorization of a letter of warning regarding the use PAP violations.
Make a motion that we take council's advice and recommendation.
Second.
Motion been made and second to accept council's advice on a letter of warning. Any further discussion? All those in favor, say aye.
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 Any opposed? Motion carries. Number 4,
2016-043261.
rather lengthy. Do y'all need more time?
Let me take another minute.
Can I ask a question of council? Under disciplinary history, where it says the second one there ending in 581, where it says education courses, do we know, are we privy to know what those courses were?
I do not have those courses.
Okay.
I could text Rihanna upstairs if you really want to know.
Same as the one above it or not? All right, although number 4 is rather lengthy, I assume there's going to be some discussion on this one.
I'm just wondering if the penalty is sufficient. This is the 3rd time this person has had a problem here.
I agree with Dr. McCary. We're also looking at a very short window of these violations of 2013, 2015, 2016. It wasn't like there's a 20-year span going on here.
I have a question.
Yes, sir.
Report date that we're dealing with, was it on here or did I miss it?
I do not believe the report date is on here. Do you want me to do you want me to see if they can get that for you?
Yes, and the reason's because I'm wondering if this is before, after, or during the other violations.
Good point.
While she's looking that up or getting that, is there any further discussion on this one?
What other penalties might be reasonable to expect in this situation if someone has had 3 penalties within a short period of time?
Dan, what do you think? I mean, what can you tell us?
I mean, we can increase the penalties, and there's no necessarily limit, especially if it's pretty close to each other. I think the question is a good one regarding, did the new complaint fall in the middle of these cases before they were resolved, maybe sometime right around 2015? And it didn't get filed until 2016. But it looks like from the 1,000 civil penalty on the 13 case, we more than doubled it to 2,500. So making this at least 3,000 could be a reasonable step up.
Problem is, it doesn't look like it's doing any good.
Right. That's the key.
I wondered that
Yeah.
if it's.
Are the civil penalties?
Yeah, this could be
Yeah.
within a few months of.
Right.
Or, the other question is, when did he, so the 2015, he had 180 days more than likely to get the coursework. The question is, did the coursework happen at or after the time of this other complaint? And if so, I think that's very relevant.
Yeah.
I've
Okay.
asked them to look at those dates. We can skip this one and go
Okay.
over it. If for some reason they don't get back to me, I'll run upstairs and figure out those.
All right, we're gonna put number 4 on hold for right now, if that's okay with the commission.
Yes.
All right, we're gonna put number 4 on hold. Go to number 5.
Number 5, I have the printed out piece for you. It's number 2016043281.
Remind us what's changed with the revision?
I had left a name in there and I needed to remove it. So if you noticed a name, then just recuse yourself. If you do not notice a name,
The paper version's what you're going to go with. It has nothing that shouldn't be on it.
Out of curiosity, do we ever have a complaint where it's been overvalued?
I think I've had a couple actually.
I'm just kinda
I
wondering.
actually
We
have.
actually
It's
have.
really, yeah.
Okay.
Since who's filing the complaint, I would guess.
That's a good question.
I would like to make a suggestion, if it's possible, in regards to both complaint number 4 and complaint number 5. In the future, would you care to put down the education courses
If
that?
we have those courses, we
Yeah,
will list them out.
Yeah, that way we just don't, because on this one too, we got 14 hours of something. And I know the corrective education, and I know there is a course now that's called corrective education.
Yep, I will make
But I
that
don't
note.
think that's it. Yeah, okay.
I would just like to express an objection to the idea of using education as a punishment. Okay.
It's hopes to deter bad behavior as
Okay,
opposed to
all right.
punishment. Corrective.
We're trying to educate them.
Yes, well, just because my students might think so, that's another matter.
All right, have you all had a chance to read number 5? I would like to say I appreciate you sending this to us before these meetings.
You're welcome.
It provides some real good bedtime material.
I won't even go there.
All right, what's the council's recommendation on number 5, please?
Recommendation on number 5 is the authorization of 30 hours of coursework to be decided by the commission.
Heard council's recommendation. Any
Move to
comments?
accept.
Okay,
We need to,
We need to determine.
we need to determine what the
the
education
course.
is.
Yeah.
second, and then we can discuss it.
Yeah.
Is there a second?
Second.
Okay, we have a motion and a second. Now, discussion on the 30 hours of coursework.
Like report writing
was
is
gonna say,
an
let's hear
issue
from the
here.
educator, yeah.
Yeah, it sounds like there were a number of places I noticed here where it said the supporting data was not found in the file. The appraisal lacked supportive value. So it sounds like there was some bad report writing here, and that might be something that would be recommended as a course to take.
You do 15 hours in report writing.
How many?
Can you do 15? 15 hours in something else if you see fit.
What's the course that's out there that's helps you back up your work file?
Well, there's an appraiser's guide to CYA, is that what you're referring to?
Yeah, well, no, that's.
That's what it's
Is that
called.
the official name?
I understand that.
I just took it last week,
There's
that's
one,
all.
yeah, there's one out there about making sure you have the right data in your work file. I can't, the name totally skips me, but I've seen that
I
course.
think it would be something about work file, data,
What it is, Mr. Educator?
Well, that's what I was going to ask. Is there, I don't know of a bank of information about the number of courses and the types of courses that are out there. And it would be helpful, I think, to everyone on the commission, but particularly to me, if I know how many courses and what the titles are, et cetera, if we could get that, and that would, allow me maybe to make some recommendations
Make some
when
kind of
courses
list of
are, there's coursework required, but we don't specify what they are, so.
I was gonna say, Cody
There are
has,
a ton of courses out there that talk about how to support your adjustments and things like that, whether sales comparison data or stuff like that. So there's an awful lot of those available.
I'm not sure this was necessarily based on comparables. It was just supporting data was not found
Right.
for just about almost, was not found in the work file. I mean, that was from the reviewer. Just said supporting data was not found in the work file. It didn't say it said across the board adjustments. It is sales comparison. I'm incorrect. So, maybe we need to have him do a sales comparison class.
I would definitely think we should make
Okay.
part of that a sales comparison class, and then possibly a report writing class. I mean, this comment throws me off. He's saying, at the time the son took over, the previous owners had passed away and their son occupied the property during the listing and was highly motivated to sell. Would that render it no longer an arm's length transaction to use as a comparable sale? If you're highly motivated to sell, then it would almost insinuate that you were under some form of a duress or had some sort of a factor
That would lead to
behind
an undervaluation.
it. I mean, or on the sales price, a lower sales price for comp three. So why would you have used that?
15-hour comparable class?
On a sales comparison?
Yeah.
I think there's a 15-hour sales comparison.
I'm just trying to think of when
Buy those
we have to
coming
make
up
him take a test,
over the
or her
next
take a test.
few.
I will bring the approved course list down next time when we do this.
Great.
You have it?
Yeah.
Cody's got it, so he can answer questions on that.
See, from a sales comparison approach, is there a 15-hour in there, Cody? Or are they just 7-hour? There's principles and procedures.
Make them take it twice.
Is there a 30-hour? Yeah. There is a 30-hour sales comparison approach? That might,
I think report writing, though, is the key thing that's missing here, I think.
Say that
What
again, Mr.
writing's tough?
Garrison.
I think it'll be tough to find one class or two classes at 15 each. I think it'll be at 1 30-hour classes.
I like the idea of a 30-hour sales comparison approach course. You can cover a lot of stuff on sales comparison approach in 30 hours.
Hopefully there's something about report writing in that, too.
There is an advanced report writing course that covers how to basically turn this into what we used to call a self-contained type report. Awful lot of those, like I said, I can't get pulled up what the schedule is, but hopefully here in a few minutes we will.
Well, we have a motion and a second for 30-hour coursework as recommended by council. So,
I would move that we make the 30-hour the 30-hour sales comparison approach course. Or that's my suggestion. We already have a motion,
Yeah,
so
we
I'm
already have a motion.
suggesting that be the 30 hours.
Okay.
I know we're discussing, so.
Still looking, Cody? Okay, we're gonna wait on Cody.
Hours means that there's an exam at the end, so it's usually qualifying.
That's true.
Recommendation.
You
Add to
can,
my-
Yeah.
you can.
Would you want to be, we would entertain going above council's motion and have him take a 30-hour comparable class as well as report writing?
Report writing.
We'd have to remove that previous motion.
Right, I understand that, but I mean, we could
I'm
do.
up for that.
We,
Can I withdraw my motion?
okay, if you wish.
We'll need to withdraw the second, too.
Okay,
don't I?
right, well, you need to withdraw yours.
I withdraw the motion.
Okay, now the second, will you withdraw? Whoever the second, Mr. Johnson?
I will.
Okay.
Withdraw.
Now, the floor is open for recommendations above and beyond the 30.
And the courses specifically that you mentioned were, what was it, report writing?
There is a residential report writing and case studies course that's 15 hours.
Okay.
Right?
There's a sales comparison course?
And then there's a 30-hour sales comparison. I move that we require the 30-hour sales comparison approach and the 15-hour appraisal report writing.
I second that motion.
All right, motion been made and second that we require him to have a 15-hour report writing and a 30-hour sales comparison approach course for a total of 45 hours.
To be satisfied within 180 days.
Okay.
Question.
And- Yes, sir.
Are we gonna specify whether it needs to be online or in classroom?
Yeah. I don't think we're going to specify. Does anyone want to
In other
specify?
words, I guess my point is, we need to make a motion that, or I guess the point is, we would allow that.
Sure.
Well, I think as long as we don't mention that in the motion itself, it's
Right.
kind of
Then they can do it.
allowable.
Oh,
Yeah, because the odds of finding those classes here within 6 months would be very rare. So, I mean, I'm fine with them.
Okay. Motion been made and seconded. We suggest we have a 15-hour report writing class and a 30-hour sales comparison approach. Any further discussion? All those in favor say aye.
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 All those opposed say no. All right, motion has passed for number 5. Do we know anything on number 4 yet?
Number 4, the effective date of the appraisal was 5/24/16.
Okay, so it's after. Okay. We're going back to number 4, gentlemen.
When was the class taken? Did we know that?
Just looking at this one, it looks like it was 2015,
13, 15, 16.
maybe around April, so 180 days from.
Almost a year after, a half year after or something like that.
All right.
And make sure I'm following you on that. I'm showing 2015 as the last one, and then this one in 2016 was how many days after that?
This one, the effective date was 5/24/16 of the appraisal.
Okay, so 5/24,
would
but
it-
the disciplinary history of 2015.
I would say that one probably came in around, our discipline could have come around April, May. So then it would have had to been completed within 180 days of that meeting.
They may not have had any of these courses.
No,
If-
no, they would have had it by October of 2015.
At the
if it came,
latest,
or
December
November, yeah.
2015.
Yeah, but
So
you're,
5 months after that,
But
the
you're tell-
effective date of the next report.
5/24/16?
Yes.
Yeah.
15, okay, I'm sorry, I thought you said 5/24/15. Sorry, gotcha.
Okay, so now we know the sequence of disciplinary actions. Have you stated what council's opinion is yet?
No, my recommendation
Okay.
was $1,000 civil penalty and 30 hours of coursework to be determined by the commission.
I think we need to be at least consistent with the previous penalty of 2,500, considering the trend that appears to be there of 1,000 and then 2,500.
I mean, based on all of the violations, you could even do 3,000 if you
I would
wanted.
think.
Yeah.
Yeah.
Yeah. I move that we have a civil penalty of 3,000 and a recommended educational.
Second.
Okay, we have a motion and a second to raise the penalty to $3,000 and the 30-hour coursework to be determined by the commission. So we'll go ahead and take a vote since we have a motion and a second, and then we'll discuss on the coursework. This is for the $3,000 and the 30 hours. All those in favor?
Aye.
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 Any opposed? All right, now let's talk about what coursework. You got 30 hours. I don't think it's going to do any good.
Taking the 15-hour use PAP and a 30-hour basic appraisal, I mean, I would almost do the sales comparison approach again, but
Talking about the record-keeping rule.
Do we have a course per se on ethics for appraisers?
Do you know if we have
Hope so.
I would hope.
I mean, it's got to be,
I mean,
I would too, but it just doesn't ring any bells, and I don't know if it's been so long since I've taken it. I may need to take it, but
I think the only ethics that I'm aware of are done by the organizations, the professional organizations, whether it be Appraisal Institute, Realtors, IRWA, or ASFMRA.
Lee. I would love to see this appraiser's file on how they got paired sales analysis
Well,
for market extraction to determine a $500 adjustment for central vacuuming, a stoop, or a security system.
well, I could offer a suggestion of a possibly informal conference, and you would have that opportunity to ask those questions directly before we make a decision on this. We used to do that many moons ago, frequently.
Who would do that?
Who would do that?
Who would conduct that? Yes.
We can decide whoever here.
Okay.
Mr. Collinsworth seems to be
Ooh,
interested in it.
No, I'm not.
There is an ethics class. Cody, go ahead and give them, but it's only 6 credits?
I see one from AI for 4 hours.
How many? 4 hours for ethics.
yeah. Suggestions on the courses, fellas?
Well, if we're talking about ethics, do we need to be dealing with coursework, or do we need to be dealing with formal hearings when you're dealing with ethics? I mean, that's kind of crossing the line there.
I was just asking if there was a course, because, I mean, it looks to me like, I know this is crazy, but in common sense, the penalty, the financial penalties and the educational penalties, from where I sit, don't appear to be
Or
working.
appear to be working.
Well, is it a matter of ethics or just lack of knowledge and ability? It's almost like you need to start at some qualifying education courses, not CE courses.
Well, they took the 15-hour use PAP and 30-hour basic appraisal last time. Those were qualifying education. If I'm assuming the basic appraisal may have been procedures and principles and procedures, maybe.
Anybody wish to make a recommendation?
I've got a question about the licensing history. When were they originally licensed? Sometimes they do show, but it doesn't on this one.
shoot her a message again.
I think some of it's with regard to record keeping I think there were some comments about that in here. Same record-keeping rule or class.
What's the class on record keeping, Cody?
That's the ethics, I bet. I'm just gonna fall under that.
That would be what's in your work file, so.
Six.
Anyone else needed?
We can come back to this one at the end if you all.
Let's
prefer.
just,
Okay, let's go to 6 then.
Number 6 is 2016036221.
All right, council's recommendation on number 6.
Council recommends authorization of a letter instruction regarding SR 2-2AX.
Heard council's recommendation.
Make a motion, we approve council's recommendation.
Second.
Motion been made and second to approve council's recommendation on number 6 of a letter of instruction. Any further discussion? All those in favor?
I got a quick question. Hold on one second, or at least give me a minute. Okay, as I was looking through this, this licensee's been licensed since 1991, 2017, with no disciplinary history. Also, they were looking at releasing some collateral, and the only thing is the reviewer reviewed the whole report and come up with one thing on 2-2AX. And he said there was no zoning in the county, and he checked the box, although I understand you should do more than check a box. I'm just sitting here thinking, really, although a letter of instruction is not disciplinary, you know, I don't know. It looks like to me you just got somebody mad about something, and they're just trying to gouge somebody. I don't know. I'm not so sure we shouldn't just dismiss it. That's just my thought, but
what's the record, do you maintain and hold the letter of instruction forever?
We do, we keep it in our file, and then what can essentially happen is if anybody does an open records request on that person, it will get released that they had one. But like
But they
Mr.
don't have to
Johnston
mark
said, it
disciplinary,
isn't disciplined, so.
But
But a lot of people do come back. I mean, for instance, that first one that I sent a letter of instruction to, he said, you know, I know it's not discipline, but it's still something on my record that I
Right.
know is there. And I mean, I agree with you on this. It's a very little violation.
that's misses.
In a long time.
Yeah.
I tend to agree with Commissioner Johnston.
I withdraw my motion.
I withdraw the second.
Okay, motion been withdrawn, and the second's been withdrawn to accept council's recommendation. Do I hear another recommendation?
I'm making a motion to dismiss.
I'll second that.
All right, on number 6, motion's been made to dismiss and second, and motion has been made to dismiss, and we have a second. Any further discussion? All those in favor say aye.
Aye.
All those opposed? All right, motion to dismiss, please, on number 6. All right, once again, let's go back to 4.
Still looking, so let's go on to 7. We might have to hold 4 till the end.
Let's just
Yeah,
do
let's
4 at
just
the very
roll.
end.
We'll just do it at the end. That way if I have to run upstairs, I can do that.
Number 7.
Okay, number 7 is 2016051461. This is a pretty short one. My recommendation was to dismiss.
All right, you've all heard the recommendation on number 7 from council. Any discussion?
Motion to approve council's recommendation.
Your second?
Second.
Motion's been made and second to accept council's recommendation on number 7. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Number 8.
Number 8 is 2016-052-661.
Classes in courtesy by any chance? And these-
We will have that list for the next meeting. That way at least I've got it in my hand.
All right, you've all read number 8. Council's recommendation on number 8, please.
Council recommends the authorization of a letter of warning regarding the above use PAP violations.
All right, you've heard council's recommendation. What's a pleasure of the committee?
Move to accept.
We hear a second?
A second.
All right, we got a motion and a second to accept council's recommendation on number 8. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Number 8 carries. Number 9.
2016-05293.
Get a chance to read number 9 yet? Council's recommendation on number 9, please.
Although it says letter of instruction, I meant authorization of a letter of warning in regards to the use PAP violations.
Could you explain the difference between those two?
Instruction is typically what we send out just to try to guide them to the right way. Warning is like, we're going to give you one more chance before we, know.
That stays in the person's record? Okay.
yeah, it's neither one are discipline.
Mm-hmm, I understand.
Yeah. But usually we give, sometimes we'll do instruction for minor things and then warning for the little bit bigger things. And I meant to do a warning on this one. That's my fault.
And although it's not a disciplinary action, if I was an outside attorney and called you and said, have you all taken any kind of action on this appraiser, would you say yes?
First of all, it depends on what state you're from. If you're not a Tennessee resident, I will not give you that information. Open Records doesn't require me to give it to anyone outside the state of Tennessee. If you were a Tennessee attorney, I would ask you to put it in writing, and then I would send you over what we've done.
Question, does the open records, only attorneys can do that, or can anybody send a letter?
Any resident of Tennessee can ask
Okay.
for that information.
I want to ask you, again, the appraisers here, do you think this rises to the level of something that requires a warning?
History has a 2014 letter of warning already
Mm-hmm.
in the file.
I understand that, yeah. But in this particular case,
From where we sit, and maybe even from where you all are, do we know, or can you tell us, are the two letters of warning, if we send him one now, are they for the same thing?
I would have to go back up and look
Okay,
at
so
the
we don't know that at this point.
Yeah, we'd
Okay.
have to look at the file and dig
Okay.
through and see if we could find the old letter that was written.
Okay. Any further discussion on council's recommendation for number 9? All right, we have a motion and a second that we accept council's recommendation on number 9.
Made that motion.
We don't yet.
I
We
didn't
don't-
think
oh,
we
I'm
did.
sorry. I
No,
thought we
didn't
voted.
think
I'm
we
sorry.
did. I just raised a question.
Oh, okay. Okay. Do we have a motion on council's recommendation for number 9? Have an alternative motion.
I'll just make one then. I move to dismiss.
Okay. Motion's been made to dismiss number 9. Do I hear a second? All right, Dr. McCary, your motion's going to die due to a lack of a second. So number 9 is still on the floor for discussion.
I make a motion, we do letter of instruction instead of.
Can you again explain, the relative seriousness of those two letters?
I mean, it's essentially just what we write in them. This is a letter of instruction. I put, the commission instructs that you follow, use PAP, or, a letter of warning, the commission, and the letter of warnings are kind of, the commission chose this route as opposed to a civil penalty, and kind of,
Is
it
one
lays out the
considered to be
same.
more serious or more?
I would go out on a limb to say most people say a letter of instruction is less than a letter of warning.
And that's what was proposed, was a letter of instruction. I'll second that motion.
Okay, we have a motion and a second to issue a letter of instruction on number 9. Any further discussion? If not, all those in favor say aye.
Aye.
Any
I would
opposed?
throw in that they get a more current dictionary, too.
What?
They've got a 3rd edition, and there's 3 editions thereafter.
I'd like to amend that motion to, within the letter instruction, it states to get a more current dictionary.
All right, any opposed? Motion carries. All right, number 9.
Number 10.
Number 10, 2016055031.
Council's recommendation, number 10.
Council recommends the authorization of 30 hours of coursework to be determined by the commission and completed within 180 days.
All right, the commission has heard the council's recommendation. Motion.
Move to approve.
All right, we got a motion and a second. Your motion's going to fail by lack of a second.
I make a motion for a letter of warning. Can I explain? Sure. There's been no disciplinary action in 15 years. Looks to me like a lot of this is boilerplate that was accidentally left in the report. Granted, there are some minor errors, and that's what the letter of instruction would be for.
Second.
All right, we have a motion and a second on the floor for a letter of instruction.
Yes.
For a letter of instruction to be sent. Any further discussion? All those in favor, say aye.
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 Any opposed? Motion carries. Thank you, Mr. Tanksville. Number 11.
I apologize. Who seconded that motion? Thank you.
I just want to say I really appreciate the way the reports are arranged by putting the respondents' comments following the reviewers. That really helps, so I appreciate that.
I've told the new disciplinary council that I will be giving them copies of mine because I said I think I've got it the way they like it now. Okay, number 11, 2016042691. Any of you who were here at our last meeting have seen this one. Last meeting, we decided to put it on litigation monitoring. I did find out after the meeting that Mississippi had not yet opened a complaint against them. So I wanted to bring it back to you and just let you know that I have, luckily, thanks to the conference in DC, I was able to talk to my Mississippi counterparts, and they have now authorized a complaint against them, and they will have an administrative hearing in December. And so I now believe that we have all authority to put it on litigation monitoring. And what will happen is I will essentially send a consent order telling this respondent that they have to let us know within 30 days of that hearing what was decided so that you all can be informed of that in January.
So from our point of view, this is kind of on hold right now.
Yeah, on
Okay.
hold, pending what happens in Mississippi.
Okay, so we don't have to take any action on this.
I just need you to vote that you're good with litigation monitoring.
Heard
Make a motion to approve litigation monitoring on this case.
Motion been made and second to wait to hear on litigation monitoring on number 11. Any further discussion? All those in favor say aye.
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 Opposed? Okay. Back to number 4.
Back to number 4. Okay, again, as I said earlier, the effective date of the appraisal was 5/24. This respondent was first licensed on 11/13/2002. And as for the 2013, I did find out that he or she took 15 hours of residential site valuation and cost approach, which was completed on 4/22/14.
Okay, now you'll have to refresh my memory, but I think we have already decided that a financial penalty of $3,000 is in effect for this. What we're trying to do now is come up with the 30-hour coursework. All right, gentlemen, the floor is open for the 30-hour coursework.
You all also have the authority to put a 6-month suspension on the license, a 3-month suspension. We can up the penalty.
Have to
Typically if the penalties.
recall that, because we had already approved.
Yeah, I wanted to
But
lay
we
that
can
out there
change
that
our
you all
mind even
have.
though we've approved that.
We're still in discussion, correct?
Yes.
Did you say that that was a 2002 licensing date?
Yes.
Okay.
My thing compared to that is we wanted to be consistent with the one we ruled on, I think, are we on 4 or 5?
4.
4. Okay, so the one we ruled on 5, we were trying to be consistent because they were similar type issues. So I guess what I'm saying is I think if we did any other additional suspensions and stuff like that, we would be going in excess of what we were intending to do on the other one. Everybody?
No, understand.
I think the reason that we're considering changing is because of the fact that on 4, there's been 2 other violations within the previous 3 years.
And you're at 3,000 now. There are over 5 violations. You could up it to a $5,000 civil penalty. Most likely with a $5,000 civil penalty, you're going to see this again in formal hearings.
But at the current time, we've approved $3,000 penalty.
You have approved 3,000 with 30 hours of courses.
Okay.
Trying to wrap my head around, for 10 years, they operated, between the hedges, unless, of course, it didn't get reported. And then all of a sudden, they just fell off the wagon here recently. I don't understand that.
Is there any way we know if this is the same company or client that's complaining? Something else going on here we're not aware of?
A great point.
This one, all I know, it was filed by a real estate agent.
A lot of times if they hear you've got disciplinary, they start picking on you, trying to push you in one way or the other. And this, if I'm not mistaken, this is a complaint about a low appraisal.
Undervalued new construction.
So ethically, in my opinion, anytime an appraiser comes in low, they're doing something they know could end up here every single time they sign that report. So I don't think we have an ethics problem. Otherwise, we would be dealing with something other than a low appraisal.
Kind of puts a light bulb over my head and says,
I know there's a lot of pressure
right,
on
you're
appraisers.
talking about my commission if I'm a real estate person, so I'm gonna turn you in.
I get both sides of it. I'm
Yeah.
just,
That's one of the reasons I thought in this specific instance, an informal conference might not be a bad idea, because it's going to shed a lot of light on that question that were brought up.
where do we stand right now? on
We're
this
still in
motion?
discussion on the coursework.
Okay. Coursework, I would suggest the same sales comparison approach, 30-hour course
Okay.
that we talked about earlier, if that's the route we decide to go down.
Okay.
I propose 30 hours of coursework for the coursework part of this.
Okay. Do we have a second on the coursework?
I'll second that.
All right, we have a motion and a second to propose 30 hours of the sales comparison for the coursework. Any further discussion? All those in favor say aye.
Wait a minute. So we're saying a $3,000 penalty
We've already voted on
and
that.
a 30-hour sales comparison approach.
Yes, sir. All we're voting on this time is the 30-hour coursework. We've already voted on the $3,000 monetary penalty.
I think we're missing something here. I just can't put my finger on it.
Okay?
I can withdraw my motion.
Are you think there might be something going on in this person's life, that these problems have come up kind of in a bunch here, as opposed, after a long period of time, that there's a pretty clean record? And that you could only determine that if there was some sort of an interview?
Are you asking me that?
Yes, Commissioner
Yes,
Johnson.
yes. We used to, not that I'm advocating we have informal conferences on every issue, but, sometimes I do think that sheds some new light on some things. And,
So would that require this gentleman come in?
yeah, normally the way that would work is there would be a panel member here, and it's in the Nashville area, so I would assume, somebody in the Nashville area with the attorney, and we just meet at their office and just basically ask questions and so forth and come back with a recommendation. And they could come back and say, I think we need to go to formal hearing. They could come back and say, I think we need to, just go with the 30 hours. But anyway, there's a lot of questions that can be asked in that situation that we can't get by just looking at this.
Okay.
And I'm not, It used to be done quite frequently back when I was on the commission the first time around, probably more than it needed to be, but in 2003 to 2006.
I'm checking
was-
statutes just to make sure that we still have that in here. I've never seen it, but I'm new.
We
so.
did it, Gary Stanford had one, just my term a couple of months, years ago.
Yeah, he did that when I was
Yeah.
here, and I've only been here 3 years, so yeah, you're exactly right.
Yeah, I don't know that you have to have a statute to meet with somebody to ask them.
I mean, I don't have an issue with this as long as I mean, like you said, I was there with them and
And are you suggesting just one of the commission members be present?
Right.
So it's not an
And
open
then,
meeting?
and then when they come back and make a recommendation, they would not, and if it went to formal hearing, they would not be involved in that process because they would know all of the details. That's usually what we used to do right before it would go to formal hearing, to make sure, rather than just go automatically into formal hearing, we'd have a conference. Because actually, years ago, the commission themselves reviewed the reports. So like, if there was a complaint, Commissioner Thomas would get the report, he would review the report and make a presentation. Then, if there were lots of questions, then that would go to an informal conference. And then once a formal hearing occurred, he doesn't even show up that day. He's not here because he knows all the details. But then we went to outside reviewers, which I think is much better. Don't get me wrong, I don't want to go back to that because then you spend all your time doing experience reviews and all of these. So we've got a better situation now, but I do think occasionally there's a question that arises, and it doesn't hurt to just have somebody that's on the commission listen, because they may have a question or insight, and Tankersley has asked some great, insightful questions today. So it's just a thought. That's because I think we're missing something. I just can't put my finger on it, though.
Okay, since we're still in discussion, let's entertain a motion to postpone the $3,000 or the education hours for now. Is that a motion you've made, Ms. Johnson?
Well, I don't know if there's a motion on the floor with a second, is that right?
Yes,
If it
currently.
is, that would have to be
Oh,
withdrawn.
we can vote on that.
Well, if we vote on that, then my suggestion is out the window, because under Robert's rules, you've had a motion and a second and action on it. And we have to make a motion to reconsider.
Well, if we defeat the motion,
You can
no.
defeat the motion, yeah.
You could do that,
Yeah.
or you could just withdraw the motion.
Here,
That motion was made, you actually made the motion,
Oh, I made-
and Dr. McCara made it, and then the 30 hours.
Oh, I made the motion for
I
30?
withdraw the 30 hours.
I don't even remember making
You made
it.
the motion on the 3,000. You made the motion on the 3,000.
Oh, that is correct, yeah. All right,
Yes.
we've been back and
Okay,
forth.
so the
Yes.
motion on
I
the-
withdraw my motion.
Okay, hang on. The motion on the education has been, on the 30-hour education has been withdrawn. Who seconded
Dr. McCara.
I will withdraw the
that?
second.
Okay, and that's been withdrawn. Gary? You want to withdraw your 3,000?
Yes, I withdraw my,
Okay, we withdraw the 3,000. Who seconded that?
Dr. McCara.
I withdraw my
Okay.
second.
Now, do we want to entertain a motion to put this on hold until we have an informal hearing? Gary? Mark, I'm sorry.
I would move for that, yes.
Okay, second? Anybody second?
A second.
Okay, we have a motion and a second to postpone number 4 until we can have an informal hearing. Any further discussion?
Are we going to set a date for that
So
Well,
we're
we're going to have to
we're gonna
appoint a
have a-
commissioner
Right,
to
right, but
work with the
let's vote on this
council
first,
and-
whether we're going to do it or not.
going to postpone pending an informal conference with the respondent.
That's right.
No, we're going to postpone these motions so that we can have an informal conference.
There's no
Motions are
motions on
gone.
the
We've already-
floor.
Okay, I mean, we're going to, any action on this is what I
Okay.
meant. Okay. Does everybody understand?
That technically is action. It's action asking the attorney and the director and.
We're gonna have
an
to reach
an
out to this
appraiser
person.
To have an informal conference. So that is actually an action.
Okay. Does everybody understand what we're voting on? All those in favor say aye.
Aye.
Any opposed? Okay, now, how do we go about appointing a commissioner?
I would say you're just going to need to vote on one.
Well,
Any volunteers?
I would suggest someone from the Nashville area, since this person is in Nashville.
I would volunteer to do it.
Mr. Tankersley has volunteered to do that.
Thank you, Commissioner.
And you can arrange that with Sarah?
Yes.
You can arrange that with
We
Mr.
will do that.
Tankersley? Okay.
Yeah, I'll have Dennis or Cody reach out and see if they can set up a date, get a couple dates, and then throw them out to you, Mike, and then we can do it here, we can do it wherever.
I'd prefer to do it here.
Okay.
All right, any further legal action?
I don't think so. Like we said, the federal government team will be here next month, so.
The 11th.
Yep, they will be here the
Is that-
9th and the 10th with us going.
That's
through-
January.
Yeah.
January,
Okay.
right, not December.
Yeah.
Right.
Okay,
But that's all I think that we have.
okay. Election of officers. How do we handle that, Ms. Roxanne?
That is our last item, so we open it up for the commission members to discuss and decide if there are any nominations for a chair and then a vice chair, and you all get to vote so that we have.
I would like to nominate Randall Thomas as next year's chairman. You were vice chair. Were you vice chair this year? Who was vice chair?
Rosie,
Yeah, Tim was
Rosie
chair and
was.
Tim was
Roxanne,
chair and-
the lady.
Right.
What's her name?
Rosie?
Rosie.
Rosie,
She was
yeah.
vice chair.
Miss Johnson, it's all, yeah.
Well, you served in that capacity at least for two meetings.
Yeah.
So, and I think you've done a good job. I'd like to nominate you as chair for next year.
I'd like to nominate Commissioner Tankersley for vice chair.
I would nominate Rex Garrison and refuse that nomination. Thank you.
Am I allowed to handle this?
I think I can, or, yeah.
Okay.
I think I can. So
Please do.
currently on nomination we have for chairman, nominated by Mr. Eric Collinsworth, is for Randall Thomas. For vice chair, we have by Dr. Warren Mekra, recommendation for Mr. Michael Tanksley, and Mr. Tanksley has recommended for vice chair Rex Garrison. So we have a motion for Randall Thomas as chair and a motion for Rex Garrison as vice chair. We would need a second for either or both of those.
Second?
Second for both?
Yes.
Have currently, as of the next meeting, yes? So for the January meeting starting, we have the chairman for this commission, Randall Thomas, as vice chair, Mr. Rex Garrison. Congratulations. Will everyone please, let me go ahead and do.
Now, do we have to vote to approve that, or is that?
Yes.
Okay.
You do, and I'm going to do it by roll call.
Okay.
You give me a second, let me make sure I've got my.
She's gonna do it by roll call.
We are voting for chair and vice chair, Mr. Rex Garrison,
Yes.
Timothy Walton, Mark Johnson,
Yes.
Randall Thomas,
Yes.
Eric Collinsworth,
Yes.
Ms. Mary's not here, Dr. Warren Mekra,
Yes.
and Mr. Michael Tankersley.
Yes.
All in agreement. Thank you.
Okay. Now, new business, Mr. Tankersley.
I have a curiosity question whether we can do something. These letters of caution, letters of, one of the things that came up today was that we keep going back and back and back and pulling these out. It's it's kind of one of these things. It doesn't matter what you do in your career. You could be 20 years down the road, but we can always go back to 1993 and pull out what you messed up that first year we were actually a commission. Is there any way we can make a rule or try to get something done where we can stop that?
As in take discipline off their
Yeah, is
record.
it after 10 years of doing nothing or 20 years of doing nothing or even 50 years of doing nothing?
I don't know that we have that authority to remove discipline from their record.
Let me say this, I was at a real estate commission meeting, and a gentleman had applied to become a real estate agent in Tennessee, and he was 64. And he had to explain why he was arrested when he was 18 for stealing a rock at a state park. And he put a rock in the trunk of his car in a state park, and the ranger was there and arrested him. So when he was 62, he was explaining to the real estate commission what he did when he was 18, and they just laughed at it.
Yeah, well, and
You
that's
know.
because their statute requires that any criminal felony conviction, you have to come before the commission before you're licensed and explain yourself.
Now, I think with that history, it leaves it up to the commission to be able to say, this is 10 years ago, let's not take it into account in our decision.
But that's not where I'm going with this. I'm going with this with E&O insurance. I'm going with this as trying to get clients. I guess what we're doing is we're talking about this, we originally had a group come up, talk about the statute of limitations for us doing stuff. So in the same regard, you know, people who've been in business and done really well for 20 years might have got in trouble because of their trainer 21 years ago. I'm not sure that there shouldn't be a way to clear that out and clean it, and that has always been an issue.
Is that something you can look at, hang on just a second, Sarah, and get back to us and tell us?
I have
mean,
no problem reaching out to the deputy counsel just to see if he has any
Yeah,
thoughts
okay.
or ideas on that.
All right, yes, sir. What do you do if I say no? Go ahead.
Well, I'll walk back to my seat. This was brought up at a prior meeting as well, when myself and Wells Eady were here in front of the commission. And that is something that's been brought to our attention as well, that there should be some way that there's a statute of limitations on claims on a historic record. I don't know if there's another profession necessarily that has that, but that
I
was
mean, I can
something
tell
we
you as an
tried to do.
attorney, if I were disciplined today, it would be on my record for the rest of my life.
Is there any
It would never
profession
go
that you
away.
know of that has that?
No, I mean, I know doctors, it stays on
Like
their
medical
record.
profession, CPAs, you would think.
CPA stays on there. I'm working for a CPA firm, yeah.
Broker's license.
See, the problem, and I agree with what you're saying.
Yeah, real
but-
estate, there stays
But
on.
in going along with what he's saying, because I do a lot of litigation work, I can also see an attorney saying, an opposing attorney saying, Mr. Thomas, have you ever had a complaint or a letter of warning or anything issued to you by the Real Estate Appraiser Commission? You know, now 31 years down the road, I'm thinking to myself, no, but when I was 21, yes. And so I'd have to sit there and say yes. And most attorneys that are good attorneys don't give you a chance to explain. They just cut you off and turn to the jury and say, see, he's an idiot. So,
Yeah, but they,
That's also called a redirect, and
Yeah,
you're
you gotta
going to
redirect.
say
Yeah,
that was
redirect.
21 years ago.
I've testified in many, I don't even know how many cases as a witness, and and if you know that coming in, they've already done the research, and your attorney should be able to disarm that pretty quick.
And I mean, I get what you're saying, but I do think that you all are very good at also looking at things and saying, okay, well, that was in, you know, that says 1999 beside it. You dismiss it very quickly. And I think that's the idea behind it, is that even insurance companies that are looking into you, I mean, doctors hold malpractice. If they did something back in the 80s and, you know, they're currently trying to get it, I mean, they're going to look at that and say, okay, there is an issue, but it was 20 years ago. So I get it, but I mean, I don't know that that's going to be worth the fight to do rulemaking if we had to do it.
Well, I guess my question is there anybody out there that's doing that? Because I do know this is something that nationwide is being discussed, because it's become a big issue, especially with background checks that are being required now for new licenses. And how far back do you actually go in the background checks? So I just wanted to bring it to the commission's attention that I think it's something we may be looking at in the future, and to keep it on the, consideration.
maybe it's something you could just look up and
Yeah,
maybe
I have
bring
no
back to
problem.
us next time.
And I know a lot of times when they're looking at those background checks, I mean, when you apply to take the bar, I mean, it tells you have to release everything in the last 10 years of any of that. So they're good about, giving a look back. I mean, Real Estate Commission, we're getting ready to do rulemaking that we're only looking back for 10 years now, instead of, as that guy, where we looked back,
Sure.
40, kind of limiting that. So I know a lot of professional organizations do that.
All right, thank you. Anybody else have any new business?
Yes, I've got one item, and I think Dennis may have passed it around, and I was looking at it earlier and realized that I had copied the wrong page out of the ethics rule for you guys, so it's not that big a deal, but it's actually regarding the record-keeping rule, and the first page is correct there. And this came from the AG's office. I've got they had sent me a contract on an assignment, and under item 16, it says contractor agrees upon completion of assignment, all documents, any original documents, any copies or materials furnished to the contractor by the Attorney General shall be returned to the Attorney General's office. This is boilerplate language they have in their contracts, and in speaking with them, I asked them to remove that in my contract, and they said, well, we can't remove that. It's boilerplate. And I said, well, it flies in the face of record-keeping rule. under USPAP, because we have to retain all those. And so they said, well, is there a way that, I said, well, I can make you a copy of the entire work file and give you that copy. And they said, no, we have to have the original. I said, so you want the original notes of when I went out and did my inspection? And he said, yeah, and you keep the copy. I'm like, well, I don't know. I said, well, let me just tell you that. I said, it doesn't, I'm not sure if retaining a copy would suffice under USPAP and give them the original or not. I'm not sure. I said, but what I'll do is I'll throw it out on the table and we can discuss it at the meeting Monday.
Yes.
Yes.
It will be USPAP. The reason I say that is because under USPAP, you don't have to have a physical file. You can keep it digital, which means everything's a copy.
Got to be
Except,
reproducible.
well, you've got to have an original copy of the report.
But that can
That's-
also be digital.
That can be digital, yes.
Okay, so everything can be digital, so since it can be digital, I would say everything can technically be a copy.
So your handwritten notes, and some of the stuff, they provide you, you don't have to turn back in. But your notes and things of that nature, you can just give them the originals and keep a copy or
Scanned,
digital.
yep.
Okay. All right.
Anything else? Any old business? Any monkey business? Entertain a motion to adjourn?
So moved.
All those in favor, do I have a second?
Second.
All those in favor? Leave.
Aye.
Aye.
Thank you very much, gentlemen and ladies.
Thank you.
Yeah.